The second factor is proximate cause and damage, and we talked about proximate cause and damage in connection with a negligence case. We've talked about proximate cause and damage in connection with a strict liability case, and I want to remind you that proximate cause and damage will be essential elements of all tort cases, with the exceptions of battery, assault, false imprisonment, and trespass to land, which don't require any damage. We also said the third factor to consider is affirmative defenses, and we talked about the affirmative defenses that apply in the intentional tort cases that we discussed. Let's talk about the affirmative defenses that apply to negligence and strict liability. And there really are two of these that we need to know about. The first one is called contributory or comparative negligence. Contributory or comparative negligence is unreasonable conduct of the plaintiff which contributed to the harm. And there are 3 points of view in existence among the United States about contributory or comparative negligence. Some jurisdictions apply what is known as the all or nothing view of contributory negligence. Under the all or nothing view of contributory negligence, if the plaintiff was negligent, that is, if the plaintiff acted unreasonably, and the plaintiff's negligence contributed to the accident, the plaintiff gets nothing. That's the all or nothing view. Some jurisdictions have adopted the pure comparative negligence approach. Under the pure comparative negligence approach, the plaintiff's recovery is diminished in proportion to the plaintiff's own fault. So, if the jury decides that the accident was the defendant's fault and that the defendant's conduct proximately caused the plaintiff's harm, the jury goes on to decide how much of the fault, if any, was the plaintiff's. And the plaintiff's recovery is reduced in proportion to the plaintiff's fault. So if the jury finds that the plaintiff was damaged to the tune of $100,000, but that 20% of the fault was the plaintiff's, then all the plaintiff can collect is $100,000 minus 20%, or $80,000. That's the pure comparative negligence approach. Plaintiff's recovery is diminished in proportion to plaintiff's fault. Some jurisdictions have adopted the modified comparative negligence approach. Under the modified comparative negligence approach, the plaintiff's recovery is diminished or reduced in proportion to the plaintiff's fault, but if the plaintiff's fault is equal to the defendant's, or in some jurisdictions greater than the defendant's, the plaintiff gets nothing. That's the modified comparative negligence approach. Suppose that a jury decides that the defendant was 20% at fault and the plaintiff was 80% at fault. In an all or nothing jurisdiction, the plaintiff gets nothing. As long as the plaintiff was at fault at all, the plaintiff gets nothing. In a pure comparative negligence jurisdiction, the plaintiff can get 20% of the damages because the plaintiff's recovery is diminished by 80%, which is what the jury found the plaintiff's fault to be. In a modified comparative negligence jurisdiction, the plaintiff would get nothing because the plaintiff's fault was greater than the defendant's fault. In the majority of jurisdictions, these defenses, all or nothing contributory negligence, pure comparative negligence, modified comparative negligence, in the majority of jurisdictions, these defenses may be raised in negligence cases, but not in strict liability cases. However, in a minority of jurisdictions, these defenses may also be raised in strict liability cases. The other important defense for us to know about is assumption of the risk. Assumption of the risk is like consent, only in a negligence or strict liability case. And incidentally, all jurisdictions allow the defense of assumption of the risk to be raised in strict liability cases as well as negligence cases. Assumption of the risk occurs when the plaintiff voluntarily encounters a known risk. And the majority of jurisdictions say When the plaintiff voluntarily encounters a known risk, the plaintiff is not entitled to recover anything. It's a complete defense to negligence. It's a complete defense to assumption of the risk. However, there are some jurisdictions, a minority of jurisdictions, which say that there are two kinds of assumption of the risk. If the plaintiff voluntarily encounters a known risk, that's a secondary assumption of the risk, and it's just another name for comparative negligence in those jurisdictions. However, if the plaintiff's relationship to the activity involved and the defendant's relationship to the activity involved justify the conclusion that the defendant did not owe the plaintiff a duty of reasonable care, there is a primary assumption of the risk, and the defendant can collect nothing in a negligence case or a strict liability case. Let me give you that again. In the majority of jurisdictions, if the plaintiff voluntarily encounters a known risk, the plaintiff gets nothing. In a minority of jurisdictions, the plaintiff's voluntary encounter with a known risk is like comparative negligence. A primary assumption of the risk occurs only when the relationship between plaintiff and defendant and the activity in which they're engaged justifies the conclusion that the defendant did not owe the plaintiff a duty of reasonable care. Most recently, a California court came to the conclusion that when a plaintiff and defendant play touch football, the nature of the activity and the nature of their relation to the activity is such that the defendant does not owe the plaintiff a duty of reasonable care. There is a primary assumption of the risk, and the plaintiff can collect nothing. All right, we've just about finished covering basics of the law of torts, but we do want to tie up one more loose end, and then we'll be ready to start discussing some specific areas of tort liability. This loose end is called vicarious liability. Vicarious means through another. And there are certain situations in the law of torts in which one person may be liable for what another person has done. We call that vicarious liability. The most common form of vicarious liability is known as respondeat superior. Respondeat superior is a doctrine of the law which makes an employer vicariously liable for torts committed by an employee acting within the scope of employment. So in order for respondeat superior to apply and make an employer liable for something the employer didn't do, it will first be necessary to show that the person who committed the tort, who actually committed the tort, was an employee. Now, people who work for me may be my employees, but they may also be my independent contractors. If I hire you and I agree to pay you $5 an hour and you agree to do just about whatever I tell you to do for $5 an hour, you're going to start work every day at 9 o'clock, you're going to work every day till 6 o'clock, you're going to take an hour off for lunch, I'm going to keep an eye on what you do, I'm going to tell you how I want you to do it, the chances are you are my employee. And I may tell you, for example, okay, today I want you to paint my house because that's what I'm assigning you to do as my employee. On the other hand, there are some people who may work for me that aren't my employees. We call them independent contractors. For example, when I want my house painted, I might just call a painter and I might say, come on over, tell me how much you want to paint my house. And he comes over and he looks the place over. He says, I'll paint your house for $250. The chances are that person is not my employee because, first of all, he doesn't work exclusively for me. Second of all, I'm paying that person for the job rather than by the hour. Third of all, I'm not going to keep my eye on that person and tell him how I want him to work, although I'll tell him how I want the house to look when he's done. I want you to paint it yellow, I want the trim to be brown, I want you to give the trim 2 coats. I can make that kind of a deal, but if he's the independent contractor, I won't have the right to stand there and watch him and tell him, no, I want you to get that corner now, get that corner now. I might have that right with my employee. So, if we're trying to decide whether I should be held liable for what the painting person did while painting the house, or let's say he, she dropped the paintbrush and it hit somebody that was walking by, We have to decide whether the person who was doing the painting was my employee or my